Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. Thank you for joining us for this post-decision episode of SCOTUScast, Cross-Border Shooting Edition. I'm your host, Christopher Goffis. On June 26, 2017, the Supreme Court decided Hernandez v. Mesa. In 2010, Sergio Adrian Hernandez Guereca, a 15-year-old Mexican national, died after being shot near the border between El Paso, Texas and Juarez, Mexico, by Jesus Mesa, Jr., a U.S. Border Patrol agent. Hernandez's parents, who contend that their son was on Mexican soil at the time of the shooting, sued Mesa in federal district court in Texas, alleging violations of the Fourth and Fifth Amendments. After hearing the case en banc, the U.S. Court of Appeals for the Fifth Circuit ultimately ruled in favor of Mesa, concluding that Hernandez could not assert a Fourth Amendment claim and that Mesa was entitled to qualified immunity on the parents' Fifth Amendment claim. In granting certiorari, the U.S. Supreme Court directed the parties to address whether Hernandez's parents could even raise their claims under Bivens v. 6 Unknown Federal Narcotics Agents, which, sovereign immunity notwithstanding, recognized an implied right of action for damages against federal officers alleged to have violated a citizen's constitutional rights. Ultimately, the court vacated the judgment of the Fifth Circuit and remanded the case. In a per curiam opinion, the court underscored that a Bivens remedy is not available when special factors counsel hesitation in the absence of affirmative action by Congress, and noted that the court had recently clarified in Ziglar v. Abbasi what constitutes a special factor counseling hesitation. The Fifth Circuit, the court directed, should on remand resolve in the first instance the extent to which Abbasi may bear on this case. The court acknowledged that the Fifth Circuit did not address the Bivens issue because that court had concluded that Hernandez lacked any Fourth Amendment rights to assert, but the Supreme Court considered it imprudent to resolve such a consequential question without a resolution of the Bivens issue first. Finally, the court indicated that the Fifth Circuit had erred in finding qualified immunity for Mesa, regardless of any Fifth Amendment violation, because the Fifth Circuit had relied on facts about Hernandez's nationality and ties to the United States that were unknown to Mesa at the time of the shooting. Justice Thomas filed a dissenting opinion. Justice Breyer filed a dissenting opinion in which Justice Ginsburg joined. Justice Gorsuch took no part in the consideration or decision of this case. And now, to discuss the case, we have Steven Giaier, who is Senior Counsel for the House Committee on Homeland Security.
This case dates back to 2010, so over 7 years ago. It was an incident of a cross-border shooting in El Paso, Texas, of a 15-year-old Mexican citizen. The shooting itself took place in what has become known as a concrete culvert in El Paso, Texas, lining the border between El Paso, Texas, and Ciudad Juarez. So it's sort of important for you to understand what this culvert is, because it plays very, very big in the case here. It is a sort of a concrete strip of land running north to south along the border. To the east is a fence on the United States side. To the west is a fence on the Mexican side. It runs about 270 feet wide. Water that used to run through the culvert, but now it's dry, and it is jointly operated and maintained by the United States and Mexico. Now, the facts of the case are in pretty great dispute. That should be set up front. But, as the opinion noted, we're dealing with a motion to dismiss, and so we have to confine ourselves to the facts as alleged in the complaint. And the facts as alleged in the complaint are that Sergio Hernandez, the 15-year-old boy, was playing with a friend in this concrete culvert, playing a game where they would run up to the U.S. fence, touch it, and then run back. At some point, Agent Mesa of the United States Border Patrol grabbed Hernandez's friend by the collar, while Hernandez ran back onto the Mexican side but still within this concrete culvert. And then at some point, Agent Mesa shot and killed Hernandez. The Department of Justice investigated the case and decided that it was not bringing criminal or civil charges against Agent Mesa, and so the Hernandez family sued in federal district court in Texas. They sought damages under Bivens, asserting the Bivens claim, saying that Mesa violated Hernandez's Fourth and Fifth Amendment rights. The district court dismissed. They granted Mesa's motion to dismiss. That was appealed to the Fifth Circuit. A three-judge panel in the Fifth Circuit reversed in part and affirmed in part. They said that Hernandez lacked any Fourth Amendment rights because he was not a U.S. citizen, not on U.S. soil, but they said that Agent Mesa violated his Fifth Amendment rights and extended Bivens to that Fifth Amendment violation, and they said that Mesa was not entitled to qualified immunity. The Fifth Circuit then heard the case in banc, and in banc panel was formed. They said that they affirmed the district court's motion dismissal. They said that there was no Fourth Amendment claim. They said they were divided on the Fifth Amendment claim, but they were unanimous that Mesa was entitled to qualified immunity. And because there was no Fourth Amendment claim and because he was entitled to Fifth Amendment immunity, they said we're not going to address the Bivens issue. And so that was appealed to the Supreme Court. It was on the docket for quite a long time, I think over a year, until they finally granted certiorari. And they accepted the two questions that were presented, which was, does the Fourth Amendment apply extraterritorially in this case? And if so, what standard is to be applied? It's sort of going back to the Boumediene case versus the Verdugo case, how are we to tell if it applies extraterritorially at all? And then can qualified immunity be granted based on facts unknown to the officer at the time of the shooting? In addition to that, the court added a third question, which was, can a Bivens claim be asserted in this case? And so the government really sort of latched on because they sought the opinion of the Solicitor General, and they really latched on to that Bivens question and briefed heavily on that and said that, in their opinion, it was the antecedent question of this case and that Bivens should not be extended. So during oral arguments, this was heard in late February, it was hard to pin down some of the justices where they were on the Fourth Amendment issue. They were trying very hard to extract a clear rule from Hernandez's attorney that could be applied in future cases. And for some people, like Chief Justice Roberts, Justice Alito, it was very clear where they were. The rule that the attorney was trying to put forward was just very, very narrow, very confined pretty much to the facts of this case and couldn't be applied in any other context. People like Justice Ginsburg was very clear, was on the other side. But people like Justice Breyer, even Justice Kagan to some extent, were sort of, at least from the oral argument, were sort of iffy, and you couldn't really tell where the vote count would lie. On the Bivens issue, on the other hand, it was very clear. There was a clear 4-4 split. And Justice Kennedy, in particular, was very clear that, in my view, was pretty hesitant to extend Bivens to the case at hand, which obviously at that time Justice Gorsuch was not on the bench, and so it was pretty clear to me that this was going to be tricky going forward for them to come to any sort of clear definitive ruling one way or the other. And so this past Monday, the ruling came out. And what they did was clearly, to me, some sort of a compromise position. They vacated the Fifth Circuit's ruling, and they sent it back. And they pretty much said two things. They said, one, you did things out of order. Two, you need to take our decision in the Abbasi case that was decided a week prior on June 19th. You need to take that into account. So what do I mean by that? They said that they latched onto the government's argument that the Bivens question was the antecedent question to be addressed before any others. So in other words, you take care of Bivens first, address that first. Is there a Bivens extension here? Yes. Okay, then move on to Fourth Amendment consideration, Fifth Amendment consideration, qualified immunity. If not, then you can stop. Fifth Circuit did the opposite. They said there's no Fourth Amendment, he has qualified immunity, and so we don't have to talk about Bivens. So the per curiam opinion said look at Bivens first. And when you're doing that, take into consideration the opinion that we just released a week prior, Ziglar v. Abbasi. I will just quote the Abbasi quote that was quoted in the Hernandez case. And they said that the Bivens inquiry with Abbasi, in mind, must concentrate on whether the judiciary is well suited, absent congressional action or instruction, to consider and weigh the costs and benefits of allowing a damages action to proceed. That, to me, is a very striking quote that was lifted from Abbasi and inserted into the Hernandez opinion, because Justice Kennedy at the oral argument, as I said, was sort of raising the red flag that this was a issue of foreign affairs that was best left to the political branches. And so that combined that with that quote And that quote was from Abbasi, was written by Justice Kennedy, and it sort of strikes me as Justice Kennedy saying, remember what I said at oral argument? Yeah, that's and then remember what I said in Abbasi. Put those two together, and probably leaning towards no Bivens extension in this case. But I could be wrong. Who knows? And it's worth addressing the difference between Abbasi and the Hernandez case. In the Abbasi case, you may know, we were dealing with a 6-member court. There was no Justice Gorsuch at the time. Justice Kagan had to recuse herself, and Justice Sotomayor had to recuse herself. So we had a very clear 4-2 decision authored by Justice Kennedy. In the Hernandez decision, Justice Gorsuch was not on the bench, but the recusals were not there. So we had a very clear 4-4 split on the Bivens issue. It was on full display. You could just tell. And so they probably didn't have a majority vote to just say, okay, we just decided Abbasi, let's apply Abbasi here, and then rule one way or the other whether or not Bivens is extended. So rather than schedule a rehearing in the fall, which they did for a couple other cases, they just came up with this compromise. It got 5 votes, and they said, okay, send it back down and take another look. So as far as this Bivens being the antecedent question, as far as always address Bivens first, they said it doesn't always have to be that way. But in this case, the Fourth Amendment question is, quote, sensitive and may have consequences that are far-reaching. And so for that reason, and I guess we can sort of use that language in saying, I guess, is that the standard for whether or not a Bivens question must come first? Is it only in cases where it may be sensitive and consequences are far-reaching? Maybe. But in this case, he said, yes, that is the case. And so they vacated the Fourth Amendment stuff, and they said the issue may not even be necessary depending on what happens in the Bivens analysis. So again, saying if the answer is no, you don't have to talk about Fourth Amendment. With the Fifth Amendment stuff and the qualified immunity, it was very interesting because the qualified immunity stuff barely came up at oral argument at all. None of the attorneys brought it up by themselves, and it was the subject of one very short question from Justice Roberts, and then that was it. And so, but they vacated that ruling, and they said that the Fifth Circuit erred in granting qualified immunity because they did so based on facts learned by the officer after the incident. They said in this case that Hernandez's nationality and the extent of his ties to the United States were not known by Officer Agent Mesa at the time of the shooting, and you can't do that. You can't take those kind of facts into account when you're deciding qualified immunity. But again, they made clear that when they were talking about qualified immunity in that section of the curiam opinion, they said if the answer to Bivens is no, you don't have to talk about it. So that was pretty much what they said in the per curiam opinion. There were 3 dissenters. The first one was Justice Thomas. He said pretty much we don't need to send this back to the Fifth Circuit. We can just decide this now. We took care of Abbasi. We can take care of Hernandez. The circumstances are very different from Bivens, and so we shouldn't apply Bivens, and we're done here. I don't know why we're wasting our time sending this back down. But there were probably just not 5 votes for that view. The other dissenters were Giaier and Ginsburg, who joined together in a dissent written by Justice Giaier. And he went into a long analysis of first he said that the whole antecedent question, or he didn't say it explicitly, but impliedly, the whole question of it being an antecedent question is, you don't have to do that. That shouldn't be the case. He's had an analysis of why a Fourth Amendment protection should be applied in this culvert, even though it's clear that he was on the Mexican side. He said that the culvert was a unique area with, quote, special border-related physical features that was jointly, end quote, jointly operated and maintained by the United States and Mexico. For this and a whole other bunch of reasons, Justice Giaier said it has sufficient involvement with and connection to the United States, and so Fourth Amendment should apply extraterritorially, which surprised me because at oral argument, Justice Giaier seemed very, not sold, if you will, on the rule that was being put forth by the Hernandez attorney. But I guess he just, has a good poker face or something like that because he just bought into it 100% and said, yep, this is exactly the type of thing that we should be applying the Fourth Amendment to. And he said he would have decided the Fourth Amendment issue and then remanded the Bivens issue back to the Fifth Circuit. So he was completely okay with going, in reverse order, if you will. So looking ahead a bit now, he's obviously going to go back to the Fifth Circuit. In my view, it's a pretty tough road ahead for the Hernandez family. It's been over 7 years since the shooting, and it's going to go on a little bit longer. If I could sort of read the tea leaves here, the court pretty much provided a clear path for the Fifth Circuit to just say no on the Bivens issue and then not address the merits and sort of give them an easy way out. As I mentioned earlier, Kennedy, during oral arguments, he voiced a lot of skepticism that the Bivens should be extended here because it involved matters of foreign affairs, and those are best left to the political branches, certainly the government, and certainly Mesa's attorneys are going to pick up on that line of thought and really drive it home back at the Fifth Circuit and then back at the Supreme Court if it comes back. Add to it that now we're not dealing with the 4-4 split that we were dealing with in February. Justice Gorsuch is on the bench. I guess you can presume that he would be with the Justice Thomas and Justice Alito, Chief Justice Roberts, and vote to not extend Bivens, and then in line with the whole antecedent question line of thinking, say we're not going to address the other stuff. So, but of course, it all depends on what panel gets chosen down at the Fifth Circuit, and it could go either way.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.